Good morning everyone. Welcome to Legal Aid Queensland's webinar on anti-discrimination law. Thanks for joining us. Sorry I said good morning and it should be this afternoon. It's 3 o'clock. Thank you for joining us today. We have one of our senior lawyers from the Civil Justice Services team, Claire Coles, who will be going through the content with you today. Before I ask Claire to come and speak to you, I'd just like to go over a few house rules. So if you could please raise a hand if your technology is all working and if you're here. Great. I can see a lot of hands raising. Thank you. You can pop those down. I'll just let you all know that we have PDF'd the presentation. So that's available under the handout section, which you'll see in the right-hand toolbar. You're welcome to download that now or after the webinar, whenever suits you best. But if you want to hang on to a copy, that would be great. I'm just going to run a quick poll. So on your screen is going to flash up the question, do you work in a rural, regional or remote area? If you don't mind answering yes or no to this. Just give you another minute to respond. And just while you're going through that, I'll just let you know that we have muted your microphones today because we will use the first half for a presentation, so that'll be a half hour. And at the end, rather than talking to us for your questions, we're going to ask you to just type into the questions box, and that's also in the right-hand side toolbar, which you'll see once we've ended the poll. So we'll let you know when the best time is to ask those questions, and we'll save them to the end. Okay, great. So we have 51% of you do work in a rural, regional and remote area and 49% in a metro area. Okay, I'll now hand you over to Claire and she'll go over the anti-discrimination law with you.
Good afternoon everyone, and thank you for joining us for this webinar today on unlawful discrimination. As Catherine said, my name is Claire Coles and I'm a senior lawyer in the Civil Justice Services team at Legal Aid Queensland. Just click through. So today we're going to cover a few things. We will look at the grounds or attributes on which unlawful discrimination can occur. I'll explain the areas of public life in which unlawful discrimination can occur and explain the different types of discrimination, so direct and indirect discrimination. We'll also have a look at the exemptions under the legislation and at sexual harassment, victimisation and vilification, and what to do if you or one of your clients has a complaint of discrimination. So there are a number of pieces of legislation which concern discrimination. In Queensland there's the Anti-Discrimination Act, and at the federal level there's 4 pieces of legislation which cover different attributes, so Age Discrimination Act, the Racial Discrimination Act, the Sex Discrimination Act and the Disability Discrimination Act. And there's also the Australian Human Rights Commission Act, which sets up the Human Rights Commission and provides it with powers to investigate and conciliate complaints of discrimination. So, sorry, I'll just briefly say that for discrimination to occur, it must be on the basis of an attribute that you possess. There must be direct or indirect discrimination in an area of public life, and it must not be excused by an exemption under the legislation. The attributes, the definitions of direct and indirect discrimination, the areas of public life and the exemptions are all defined by the laws of the state and federal parliaments, which I've mentioned earlier. So the first area which we'll discuss are the attributes covered by the legislation, and you'll see on the PowerPoint slides that there's a list of those attributes, and they're quite wide-ranging. So basically they are sex, so whether you're male or female, your relationship status, whether you're pregnant or not, your parental status, whether you breastfeed, your age, race, impairment or disability, your religious belief or religious activity, or whether you don't participate in a religious activity or hold a religious belief, your political belief or political activity, whether you participate in trade union activities or a member of a trade union, lawful sexual activity, which has a very specific definition. It means whether a person is lawfully employed as a sex worker, whether they're employed, whether they're self-employed or not. There's also gender identity, which is a person's perception of their own gender rather than their sex, which is their outward expression of their sex. Sexuality is whether a person is heterosexual, homosexual, bisexual, a person's family responsibilities, or you can also be bring a complaint of discrimination if you've been discriminated against on the basis of your association with or relationship to a person identified in one of those above groups. I had a question from one of the attendees before the webinar, and that person asked that I explain discrimination on the basis of mental and physical disability or mental illness. So I thought I would run through impairment and disability in a little bit more detail. Impairment and disability are very broadly defined in the legislation. In the Queensland Anti-Discrimination Act, the term impairment is used, and in the Federal Disability Discrimination Act, the term disability is used, but it's they're very interchangeable. And those are, this is from the definition of the legislation, which goes through a range of different conditions and illnesses, I guess, that a person could suffer from, which are used to define impairment. So the definition of disability in the Disability Discrimination Act is quite similar, but it also includes behaviours linked with a disability. So, for example, aggressive behaviour resulting from an acquired brain injury. Under the Anti-Discrimination Act, discrimination based on a behaviour is lawful even if the behaviour is a result of the disability. So that means, for example, if an autistic child exhibited violent behaviour, it would be lawful for the school to expel the child because of the violent behaviour, even if that behaviour was linked to their disability. The legislation covers a wide range of impairments or disabilities and includes physical disabilities, mental illness and other illnesses. The next thing that you need to look at in discrimination is the fact that only some discrimination is against the law. To be unlawful, the discrimination must occur in an area of public life that is set out in the legislation. Generally, the law doesn't prohibit discrimination in private life. So the areas of public life covered by the legislation are work and work-related areas. So, for example, applying for a job, doing work experience or volunteer work, as well as in your day-to-day workplace. Education, so school, TAFE, uni or other place of education like a private training college. Obtaining goods and services, which includes accessing premises or facilities, banking, the supply of loans, finance or credit and insurance, transport and travel. And it can also include some access to certain police services and also certain services provided by prisons. Accommodation and pre-accommodation areas, so applying to rent a property or renting a property, or holiday accommodation, all of those things. There's a specific section in the Queensland Act relating to buying real estate, as well as joining or as a member of a club. It's important to note that not-for-profit clubs are not covered by the legislation, but profit-making clubs are covered. So some examples would be not being offered a job because of your race or nationality, being sacked from your job because of your religious beliefs, a refusal to rent you a house because you have children, or having comments made about you by a teacher because of your sexuality. There are two types of discrimination, and this is the next thing that must be shown in a discrimination action. So there's direct discrimination and indirect discrimination. Direct discrimination is where you're treated less favourably than other people because of your attribute. To prove direct discrimination, you have to show that the respondent treated you less favourably or worse than another person without the attribute would have been treated in circumstances that are the same or not materially different. So there's a few elements which make up the definition of direct discrimination. Those are that there has to be less favourable treatment, that treatment is less favourable than a person without that attribute would have been treated in the same or similar circumstances. The idea of the treatment being less favourable than a person without an attribute is called the comparator test, and the comparison can be made to an actual person in similar circumstances to the applicant who doesn't have the attribute, or if an actual person doesn't exist, then the court will look at a hypothetical person and how that person would have been treated in the circumstances. And the treatment, under the Queensland Act, the treatment on the basis of the attribute must be a substantial reason for the treatment if there are two or more reasons. The definition of direct discrimination differs in some of the other legislation. So in some acts the comparator test has been removed, which can make it easier to prove a claim of direct discrimination. In some legislation, like the Disability Discrimination Act, the attribute does not need to be the substantial reason, but just one of the reasons. So it's important that people with discrimination claims seek legal advice before choosing a jurisdiction in which to bring their claim, because there are a range of factors that need to be taken into account in terms of what would be the best jurisdiction given their circumstances. An example of direct discrimination would be where an applicant who is a refugee from Africa goes into a real estate agent to look for a house to rent. They're told that there's no house available, but then another person who's a white Australian goes into the real estate agent and is offered a house. So the original applicant could have an argument that the reason why they were told there was no houses available is because they're an African person and not because there's not actually any property available for rent. The other kind of discrimination under the legislation is indirect discrimination. And indirect discrimination is where you are treated the same as everybody else, but there is an unfair impact on you because of your attribute and that it's not reasonable in the circumstances. To prove indirect discrimination under the Discrimination Act, you have to show that the respondent imposed or proposed to impose a term on you, that you were not able to comply with that term, and that a higher proportion of people without your attribute could comply with the term, and that the term is not reasonable in the circumstances. There are also slightly different definitions of indirect discrimination under some of the federal legislation. So an easy example of indirect discrimination would be where you have a disability, which means that you cannot use the stairs and because you're in a wheelchair, and you can't get into a public building because it doesn't have a ramp. So the term imposed would be that to enter the building you have to use stairs, but you cannot comply with that term because you're in a wheelchair and you can't use the stairs to enter the building. Another example is would be where a woman requests a female doctor. She requires examination at a hospital. She explains that culturally she cannot have a male doctor examine her, and the hospital refuses to provide the woman with a female doctor even though one is available. So she can't comply with the term that a male doctor examine her, and the reason that she can't comply is because of her cultural beliefs, which are an attribute under the legislation. So also a situation of indirect discrimination. There are many exemptions under the legislation, and It's up to the respondent in a discrimination case to raise an exemption and to prove it, but it's useful for people to be aware of what the exemptions are if they're looking at bringing a discrimination claim. So there's many exemptions that are specific to a particular area of public life, such as the most common exemption raised in relation to work is that the person cannot perform the genuine occupational requirements of their job because of their impairment. And so if they're dismissed, then their employer might argue that the conduct may have been discriminatory, but there's an exemption which applies because the person can't perform the work. There's also a specific exemption in relation to working with children, specifically in relation to lawful sexual activity and gender identity. It's also lawful to pay someone under 21 years old less because of their age. And you do not have to provide special services or facilities to another person if doing so would cause unjustifiable hardship. And I'll explain what unjustifiable hardship is in a moment because it comes up quite often. There's also specific exemptions in relation to accommodation. So it's not unlawful for a person to discriminate in deciding who is to reside in accommodation that they or a near relative live in, as long as the accommodation is not for more than 4 people. There's exemptions relating to accommodation for specific purposes, such as work or for students. There are also specific exemptions relating to the membership of clubs where a person is not a member of a group with an attribute for whom the club was established. So, for example, if the club was established wholly or mainly to preserve a minority culture or to prevent or reduce disadvantage suffered by people of that group, then it would be reasonable to refuse a person who was not part of that minority culture to join. There's also specific exemptions in relation to goods and services. So a person can restrict access to land or buildings of cultural or religious significance by people who are not of a particular sex or age or race or religion if the restriction is in accordance with the culture or the doctrine of the religion concerned. It's also not unlawful to offer age-based benefits like travel concessions or seniors cards, that kind of thing. You can also require a child to be accompanied by an adult if there's a reasonable risk that the child may cause a disruption or endanger him or herself if they're not accompanied by an adult. There are also a large number of exemptions in the Act which apply to all areas, and there's a list of some of those there, and you know, they do come up from time to time, and I'm happy to run through them if anyone has specific questions, but there are quite a few. Also, you can make an application to the Queensland Civil and Administrative Tribunal for a specific exemption for an organisation or a business to be exempt from the operation of the Act in relation to a particular thing. Those exemptions are quite common in relation to the provision of accommodation or specific services targeted at particular groups, or sometimes also in relation to employment advertising where they want to target a minority group for a particular job. So an exemption that is often raised is that the respondent would suffer unjustifiable hardship if they supplied special services or facilities to a person who required them. Whether something amounts to unjustifiable hardship depends on the nature and cost of the facilities, the financial circumstances of the person supplying those services or facilities, the disruption and nature of benefit or the detriment to all of the parties involved. For example, the tribunal found that a $300,000 lift for wheelchair access to the convention centre was not an unjustifiable hardship for the Queensland government. So it really does depend on the circumstances of the parties and what is reasonable in those circumstances. The Anti-Discrimination Act and some of the federal acts also contain other causes of action apart from discrimination. So I'll explain those to you now. The first of those is sexual harassment. So there's provisions under the Anti-Discrimination Act and also the Sex Discrimination Act at the federal level relating to sexual harassment. Sexual harassment has the following elements. So there must be unwelcome conduct of a sexual nature in circumstances where a reasonable person would have anticipated that the other person would be humiliated, intimidated or offended. Under the Sex Discrimination Act, the conduct must occur in an area of public life in which the legislation covers. Under the Anti-Discrimination Act, it's not necessary to show that was in an area of public life. So sexual harassment includes unsolicited acts of physical intimacy, unsolicited demands or requests for sexual favours, remarks with sexual connotations, and other unwelcome sexual conduct. Victimisation is also unlawful under the Anti-Discrimination Act and all of the federal acts. Victimisation occurs when a person who has complained of discrimination or intends to complain of discrimination or sexual harassment is subject to a detriment. This is a separate complaint under the Act, so you could reasonably have a discrimination complaint and a complaint of victimisation in the one complaint. Similarly, you could have a complaint of discrimination and sexual harassment and victimisation in the same complaint. An example of victimisation is in the case of Al-Wafa and England and Kennedy Taylor. Mr. Al-Wafa complained that he was the victim of racial discrimination because of remarks made that he took offence to. Because he made a complaint to the company he worked for, because he made the complaint of racial discrimination, the company he worked for did not give him a reference. Even though he lost his discrimination complaint, the company was found to have victimised him and the tribunal ordered the company to give him a detailed reference and to pay him $5,000. So he still obtained an outcome even though he couldn't make out his race discrimination complaint. Vilification is unlawful under the Anti-Discrimination Act. Each of the following 5 elements must be proved in a vilification complaint. So there must be a public act that incites hatred, serious contempt or severe ridicule of a group of a person or a group of people on the grounds of race, religion, sexuality or gender identity, and that's not exempt under the legislation. And there are exemptions for fair report, public act unreasonably and in good faith, and for public interest purposes. So this claim of vilification really goes further than race or sex or gender identity complaint of discrimination. There has to be incitement of hatred or serious contempt or severe ridicule. So it's a more serious kind of complaint. There's also an offence provision in the Anti-Discrimination Act. So where there is vilification, which includes threats of physical harm or actual physical harm to somebody, then the person can be charged with an offence under the legislation. I also just wanted to mention that there is also, you've probably heard about Section 18C of the Racial Discrimination Act, which contains provisions about racial hatred. Those sections are similar to the vilification provisions in the Queensland Act, except they are a little, a little lower standard, which is why they're a bit controversial, I guess, or have been in the media recently. So in terms of making a complaint of discrimination, it's important to note that there's a time limit which applies to making a complaint of discrimination. you must make the complaint within 12 months of the date of the discriminatory conduct. There's a discretion for the Anti-Discrimination Commission to accept a complaint about conduct which occurred more than 12 months prior to the complaint being made if the complainant can show good cause. And the ADCQ will consider the length of the delay, who the delay is attributable to, the circumstances of the complaint, whether there's been satisfactory explanation for the delay, and whether the delay will cause prejudice to the respondent. It's not uncommon for people's complaints to be or parts of complaints to be accepted out of time, but there is an extra process that the person has to go through before the complaint will be accepted. So a complaint can be made against a person who has committed the act of discrimination or sexual harassment or victimisation or vilification, and also, if appropriate, their employer. So an employer can be vicariously liable for the conduct of their employee, and a complaint can be made against either or both of them. There's a defence for the employer if they can prove that they took reasonable steps to prevent the contravention of the Act. Reasonable steps can include things such as training for staff regarding anti-discrimination practices, grievance procedures, posters reminding staff of their obligation and that kind of thing in the workplace. But it's good to keep in mind that an employer can also be vicariously liable for the conduct of their employees. So there's a two-tiered complaints process. Under the Anti-Discrimination Act, a complaint's first made to the Anti-Discrimination Commission Queensland, and then if it doesn't settle at the conciliation stage, it can then be referred to the Queensland Civil and Administrative Tribunal. If a complaint is made under one of the federal acts, then the complaint needs to be made to the Australian Human Rights Commission. And then an application can be brought in the Federal Circuit Court. I've noticed an error on the slides. The Federal Magistrates Court doesn't exist in Queensland anymore, so it would be the Federal Circuit Court or the Federal Court, depending on the amount of money that they're seeking. So in both the ADCQ and the Australian Human Rights Commission, there's a compulsory conciliation stage after the complaint has been accepted. The purpose of the conciliation is to try and resolve the dispute. If the matter progresses to QCAT, there's usually two conciliation conferences held, one in the ADCQ and then one before the hearing in the tribunal. And the Federal Circuit Court usually orders a mediation before a hearing as well. So there's a number of opportunities for the parties to try and resolve the dispute themselves. At conciliation, the parties can agree to whatever they want to resolve the dispute. The legislation sets out a range of orders that the tribunal has powers to award at a hearing, and these are similar orders that can be made in the federal jurisdiction as well. The possible outcomes include a public or a private apology, reference, reinstatement, training, the requirement to implement training and policies in a workplace or a business. The tribunal can also award compensation for hurt, humiliation, insult, embarrassment and offence. You can get an order for compensation for lost wages, for the cost of counselling and other medical costs, and other out-of-pocket expenses that people have suffered because of the discrimination or harassment. Often people who have been discriminated against in the workplace have a number of claims that they must choose between. It's important that anyone who has been dismissed seeks immediate legal advice, because employees only have 21 days from the date of dismissal to lodge an unfair dismissal or general protections application in the Fair Work Commission. I might just say that this applies to national system employees, so not people who are employed in Queensland by the state or government or local councils, but everyone else is typically covered by the Fair Work Act. So a worker might have related claims for a general dismissal dispute, an unfair dismissal dispute, a general protections claim, a bullying complaint and a discrimination complaint. In most circumstances, a worker can't bring more than one of these complaints about the same circumstances. So it's really important that if you have clients or if you yourself are in this situation, that you seek immediate advice to work out their best jurisdiction, because if you wait too long, then you won't have a choice. You'll be forced into one of the jurisdictions that might not be so appropriate. Okay. So legal aid can provide legal information about discrimination in employment matters. There's information on our website, in our publications, which are also available on the website, through our phone line, and the call centre operators can give information. We provide legal advice by phone, face-to-face, and in certain circumstances via video link. We also provide legal representation to people who are eligible. We practice in criminal, family and civil law, and that includes anti-discrimination and employment law. Everyone is entitled to access free legal information on our website. Our advice services are targeted to financially disadvantaged Queenslanders, and we have a means and a merits test to decide whether a person is eligible for a lawyer to represent them in court, and there's a process, an application process, which is available on our website as well. That's just some useful contact information. The Anti-Discrimination Commission Queensland website has a lot of information on it, really useful fact sheets about the different areas of discrimination, and also about the decided cases, the kind of orders that the tribunal has made. QCAT's website also has useful information, as does oh, that website's wrong too, I've just noticed. So the Australian Human Rights Commission website is www.ahrc.gov.au. And the Fair Work Ombudsman's website also has information about discrimination in employment. It's now time for questions. So if you have a question, could you please type it into the little box on the bottom right-hand side of your screen, and we will work through the questions as they come. I did get some questions from a couple of attendees prior to the webinar today, so I might go through those questions first. Jonathan has asked whether I could include some information on anti-discrimination for people with mental and physical difficulties. Hopefully I addressed that issue in the body of my presentation, but basically a person with a mental or physical disability would have an attribute under the legislation. You would then need to look at whether there's been direct or indirect discrimination in an area of public life, and that there were no exemptions that applied. And I would recommend that anyone who is concerned that they've been discriminated against seek legal advice about how the law applies to their situation. Michelle has asked how to address employers' discrimination during the recruitment and job interview process. This is a question that comes up quite a lot. Work is one of the areas of public life in the legislation, as I said earlier, and most acts, including the Anti-Discrimination Act, also include the area of pre-work. So that means that employers cannot discriminate in advertising jobs or in the interview or recruitment process unless one of the exemptions apply. So if there are clients who have been discriminated against, have either been offered a job, and then, you know, when the employer finds out that that person has an impairment, for example, the job is no longer being offered, then those people might have a discrimination claim. The other question I had was from Donna, who asked if somebody who has already had a bullying and harassment claim investigated by a company, and the company has said that there is no grounds for the complaint, is there another avenue of investigation or complaint? The avenues available to somebody in this situation will depend on the nature of the bullying and harassment. If there is a discriminatory aspect, then the person may be able to make a complaint of discrimination. if it's bullying with no discrimination, then the person may be able to make a complaint to the Fair Work Commission about bullying. But a person in a situation like that really should get legal advice to work out what the best option is available for them. So I might just have a drink of water, but we've got a couple of questions through, so I'll answer those as best I can. The first question is, have I had many cases for anti-discrimination for people with disabilities? And if so, how successful have those cases been? That's a tricky question. The answer is there are a lot of cases to do with people with disabilities. In terms of how successful those have been, it really does depend. I know that is not a very satisfactory answer, but I think if you wanted to see kind of the range of outcomes that people have been able to obtain through a discrimination process where there's been discrimination on the basis of a disability or impairment, the best place to look would be on the Anti-Discrimination Commission website. They publish a list of outcomes at the tribunal, and what that list is the decided cases. It gives a brief overview of the case and also the orders made by the tribunal. So you can get a feel for the kind of matters that are being decided and also the way the tribunal is deciding them. On the Australian Human Rights Commission website, there's a really useful table which is, I don't think is updated enough as much as it should be, but it lists the outcomes that people have obtained through conciliation, which is really useful because mostly the conciliation process is confidential, so we're not aware of matters which are going to the Commission and which are settling at conciliation except where they're published in this table. And so that can also give you a really good feel for the kind of complaints that people are making and the outcomes that they're able to negotiate at conciliation. So that might give you a good idea about how successful cases have been. There's certainly been some very successful disability discrimination cases, and there's also been some, because of a decision of the High Court in a case called Purvis, there's also been some decisions which seem quite unfair for people with disabilities. Okay, so the next question is, if somebody didn't tow my car after repeatedly asking them, but then male got on the phone after 6 weeks and the car was towed that day by the insurer, is it discrimination when there's no proof by me, the complainant? This is quite a specific question and I can't give legal advice in this forum, but I mean, it's possible that that could be a complaint related to sex, so whether you're female or male, and depending on the circumstances, there may be a discrimination complaint in there. But the person that asked that question may wish to arrange an appointment for legal advice if they would like some more advice about that one. Next question is, in your experience, are employers usually accommodating at the conciliation stage or at the time when legal aid start to intervene? Again, we have quite wide-ranging experiences in relation to the receptiveness of other parties. I think something like, I think it's about 70 or 80, quite a high percentage of matters do actually settle at conciliation. So I think that's a good, a good indicator that parties are willing to participate in the conciliation process and that people are able to reach outcomes which they're, able to live with, even if they're not super happy with them. I'm not sure. Legal aid does represent clients in the conciliation stage, but typically we don't have a lot of engagement with the other party until the day of conciliation. So you know, I'm not sure how much impact our involvement has in having the matter resolved at conciliation, but I'd hope to think that was a bit. So another question is, how long does it take to get to conciliation? That's a good question. It does. It depends on your complaint, but typically if you make a complaint to the Anti-Discrimination Commission and the complaint is accepted pretty quickly, then it can, you know, it's between a month or 6 weeks from the time you make the complaint to when the conciliation date is listed. If there's an issue arising to do with complaints made out of time, so if you've made the complaint more than 12 months after the act of discrimination, then that process is longer because the Commission first have to make a decision about that out of time application, which involves asking the parties for submissions and then getting back. So that can take a few more months. And how taxing is the process? For some people it can be quite taxing. It really does depend on the subject of the complaint and what the other party is like. The conciliation process itself, the tribunal, the Commission, at least the Anti-Discrimination Commission where I have most experience, really try to help the parties through the conciliation process. So when you make a complaint, you're assigned a conciliator, so a person who will conciliate your dispute, and that person contacts the applicant and the respondent prior to the conciliation. They can conduct the conciliation in a range of different ways. So sometimes they're done face-to-face if all the parties are in the same place. Sometimes they're done by telephone. If there's sensitive issues, especially where there's been sexual harassment, then they might conduct what's called a shuttle mediation, where the parties aren't in the same room for very long and the conciliator goes between them. So all of those things, I guess, are designed to help make the process less taxing on the parties, but it's still a adversarial process, and though you're trying to reach agreement, it can still be quite confronting for people to have to address these issues and to talk about them openly. If your matter doesn't settle at conciliation and it goes to the tribunal, then that process is like a proper court process, so you have to present evidence, you might need to be cross-examined, so that can be more taxing for people, especially if they're self-represented. Is there any other questions? Oh, sorry, there's one more. Okay, so the question is, are lawyers or support workers or caseworkers allowed to attend the conciliation? The answer to that is yes, they are. You do need to get permission from the conciliator to attend on behalf of the client. We have no problem being allowed to attend. I'm not sure whether non-legal workers, so support workers or case workers, would have any greater difficulty. I don't think they do for the conciliation. In terms of, and so you normally are allowed to attend as long as you have the permission of the conciliator and also, excuse me, and of the client, obviously. I guess one of the most important, one of the most difficult things about discrimination matters is that everybody has an idea about colloquially what discrimination is, but actually it's a very technical area of law, and so if you have a client or you yourself have a discrimination issue, I think it's always best to receive advice, because there are quite a number of jurisdictions where you could commence proceedings, and also there are benefits and disadvantages of each of those jurisdictions. Excuse me. One of the things I didn't mention is that in the federal jurisdiction, so if you commence a complaint in the Australian Human Rights Commission and your matter doesn't settle at conciliation, if it goes to the federal court or the federal circuit court, the federal circuit court is a cost jurisdiction. So what that means is if you're unsuccessful, typically there will be an order made that you pay the other party's legal costs or a portion of them. And similarly, if you're successful, then the other party may be ordered to pay your legal costs. So costs follow the event in that court. Whereas in QCAT, so if you make a complaint in the Anti-Discrimination Commission in Queensland and then your matter is referred to QCAT, QCAT is a no-cost jurisdiction except in particular circumstances where the tribunal feels that it is in the interests of justice to make a costs order, and typically that's where parties or a party to the proceeding has done something to delay the tribunal process or hasn't responded in some way. So there's less cost risk in QCAT, which can be a big advantage for people who are coming up against a company on the other side or or are concerned about costs, which is most people who are litigating. There is another question. So with regard to victimisation, if it's ongoing, is there a time limit for making a complaint? So this applies to not just victimisation, but all of the causes of action under the Anti-Discrimination Act. And that is often discrimination or victimisation or sexual harassment will be ongoing. So the time limit still applies. So the Commission can only consider acts of discrimination or sexual harassment or victimisation that occurred in the 12 months prior to the complaint being lodged. However, if there are things that happened prior to that time, so prior to the 12 months before, then the Commission has a discretion to accept the earlier complaints if there is good cause, which is what I explained before. So typically what will happen is if you have a complaint which has some component of out of time complaints and some component of complaints which are within the 12-month time frame, they will accept the in-time complaints, and then they will ask for submissions about why they should also accept the earlier part of the complaint. So it's always taken from the act of discrimination or the act of victimisation or the act of sexual harassment. So if that's more than 12 months old, then that particular act of discrimination or victimisation or sexual harassment can't be included unless the Commission gives you permission to include it.
So Claire, before we wrap up, could you just tell the audience if they're to take away 2 or 3 points from today, what would be the most important things to take away?
Okay, I think the most important things to take away are to remember that to be successful in a complaint of discrimination, you need to show that you have an attribute, that it occurred in an area of public life, that there is direct or indirect discrimination, and that there's no exemption that applies. And the other thing that I would recommend is that people should get legal advice before deciding which jurisdiction to commence a complaint in, because there are a lot of technicalities and there's also pitfalls. If you commence in the wrong jurisdiction, then you won't always be able to bring a complaint in the correct jurisdiction. So it's really important to have advice if you're concerned.
Okay.
Thank you. Thanks very much.
Just like to say thank you to our audience for coming this afternoon to listen to our webinar on anti-discrimination law, and for all of those questions that you sent through as well. And a big thank you to Claire, who provided us with the great content today. We are running a series of regular webinars now, so please keep an eye out on our website. We will advertise them there on the Community Workers page. So if you haven't had a look at that yet on our new website, please go and have a look because there are some more useful links for you there. If you do have a question that didn't get answered today, you are able to email webinars, WEBINARS @legalaid.qld.gov.au. The session will also be recorded, so if you know of anyone who might find it useful who wasn't able to come this afternoon, or you just want to refresh, then this will be captioned and popped online again through the Community Workers page and on our YouTube channel in the coming months. So thank you very much everyone, and thanks again Claire.